I'm not really. I could just do right here.
We'll get through.
It'll come to us.
Good evening.
Good evening.
Keep seeing me.
I hereby call this February the 11th meeting of the Public Safety Committee to order. As always, we'd like to thank our brave women and our brave men of our public safety departments for the work that they do every single day. Our public safety departments are led by the Emergency Management Department, Mr. August Vernon, who's with us today. Also, the police department is led by Chief Thompson. Thank you for being here today and for your work. Our fire department is led by Chief Mayo. Thank you for being here today, sir, and for your work. We also have our public safety attorney, Ms. Lori Sykes, here, and representation from the city attorney's office, Mr. Al Andrews. I'd like to thank all of our assistant city managers, led by our city manager, Mr. Lee Garrity. We appreciate the work that you do to help our city to be a better place to live, work, and relax. There are 4 items on the general agenda today. There's an item discussing an ordinance to regulate the use of electronic scooters. There's an item considering amendments to the abandoned, junked, safety, and health hazard vehicles and vehicle impoundment codes. There's an item requesting to apply for participation in 2019 Watch for Me North Carolina program. And lastly, there is information on urban hunting opportunities. Items on the consent agenda are approved with one sweeping motion unless as a member of this committee wishes to be pulled for consideration. Members of the committee, are there any items on the consent agenda that we should consider or have pulled for consideration? If not, I entertain a motion.
So move approval of the items. Second.
It's been motioned and properly seconded. All in favor, please vote yes. Opposers, likewise. That is unanimous. The consent agenda is approved. Item G1, please.
G1, ordinance to regulate the use of electric scooters and manage shared mobility system operators in the city of Winston-Salem.
Members of the committee, we've had ample discussion about this item. Before we move for consideration, this is an action request. I'd like to get a brief report from our Assistant City Manager, Mr. Damon DeCane. You have the floor, sir.
Good evening, Chairman Taylor, Mayor Pro Tem, members of the committee. Staff has returned to answer your questions from last month when we presented this item. So with that, I'll turn it over to the City Attorney's Office and our Department of Transportation.
All right, yes, ma'am. If you'll give your name for the record.
Yes, hello, Council. My name is Marilena Jensen Goodhold. I'm an Assistant City Attorney. And we presented to you a first draft of the ordinance last month. We have come back with some edits that we made in response to comments that Council made last month in both Public Works and Public Safety Committees. Let me begin, though, by saying that we recommend holding this item in committee another month to give us a chance to talk to the industry about the ordinance, get some feedback, and make any additional edits that arise out of those discussions. I would like to go over some of the requests from Council from last month and then explain how we have addressed them or if there are some items that remain to be addressed.
Please do. You have the floor.
Yes. So last month there was a concern about lowering the age limit for the use of scooters to 15 or 16 years old. Our original requirement was for 18 years. So we have lowered that to 16 years old, and that is housed in 78370F1 of the ordinance. There was also a concern expressed about education, outreach, and communication. And so we have several requirements for the permittees to communicate to customers what data will be collected and with whom it will be shared. Permittees will have to implement programs to educate customers on safe operation, applicable laws, and manufacturers' recommendations. Permittees will have to communicate sufficient information regarding rates and charges. They will have to maintain a 24-hour hotline and a local office open during business hours. Applicants will also have to include on their applications for permits what their plans are for educating customers about laws, safety, and manufacturers' warnings, and for notifying customers of inappropriate usage. And so those are housed in 78370D, G, H, I, J, and then 372C, 8, double D, and double E. We had a question about how we enforce compliance, and in 375 we can revoke, suspend, or deny a permit. In 376 we can impound a device and charge impound fees, and in 378 we can impose civil penalties and sue for abatement or mandatory or prohibitory injunction, and violators will have to reimburse the city its investigative costs. We had a question about who the director is we referenced in the ordinance, the Director of Transportation. had been delegated various decision-making authorities, and so we have now changed that to the city manager everywhere in the ordinance. We also had a question about what the costs are to the city and what our fee structure will be. Councilmember Larson requested some more specifics and clarity about the fee structure. So we have included a section 78-379, which is a schedule of the fees and penalties that will be assessed. There was also an inquiry about the period for abandonment of a scooter and a dockless bicycle. Currently in the ordinance, if a scooter is abandoned in the same place for a period of 72 hours, or a dockless bicycle for a period of 7 days, it has to be moved. And we do actually have already a provision in the ordinance which requires any improperly parked devices to be removed after 2 hours or within 2 hours. So we think that's probably addressed in the ordinance. There was a concern about visibility of scooters on streets at night and the need for safety lights. So we got some input from the police department, and we incorporated a provision in 78-369F, which requires that each scooter be equipped with front and rear lights that emit white light visible from a distance of 500 feet. And we'll probably add a requirement that those lights have an always-on feature that renders them continuously lit during rides. There was also a concern about the hours of operation, and so we have limited the hours of operation now so that scooters cannot be rented or used as part of a shared device program between the hours of 9 p.m. and 6 a.m. in the morning. There was a request from council also to include some citizens on the operator of the permittee selection committee. So we have amended 78-373A to say that the permittee selection committee will include one or more representatives from the public who are not employees of the city and who are appointed by the city manager. We had a provision requiring device operating areas, and we have since decided that the device operating areas for the micromobility devices should be citywide, so that's also an amendment to the ordinance. There was a suggestion by Councilmember Bessie, that we could ratchet up the fee depending on the egregiousness of the offense. The impound fee, we could do a $150 fine for a device improperly parked on the sidewalk, and perhaps a $300 fine for a device ridden in the street in a hazardous manner. And that's something that we plan to implement in section 78-379 of the ordinance. There was also an objection to requiring companies to include their mechanics and their juicers. Those are the people who charge the devices as additional insureds on the company's insurance policies. So we removed that requirement from the ordinance. However, one note about that is that if the companies are not required to insure their subcontractors as additional insureds, that means that if we were to make a claim against an insurance company, the insurance company would not cover that claim. And of course, the indemnification that you receive from the company is only as good as the insurance policy that exists to back it up. There are also some other liability concerns that need to be considered in terms of whether to require additional insured status for subcontractors. And that is that when you have chargers and mechanics picking up devices and transporting them, and also servicing them, if there's an error, for example, in the maintenance of the device. A colleague related to me an example from Washington, D.C., where a device was improperly maintained, the brakes failed, and a gentleman died as a result. If you don't have something in place to require that the company have the subcontractors name the city and also the subcontractors as additional insured, there could be a liability gap there. Also, with respect to the ADA, there could be some exposure there. If the federal government comes in and says you should have provided a location for these devices to be parked in a certain location, not obstructing access to the public right-of-way. And for those reasons, indemnity, insurance, and liability are issues that should be considered very carefully. There was also a concern about the length of the ordinance, and so we kind of benchmarked a little bit against some other ordinances. And so some of the longer ordinances that exist, Charlotte's ordinance is 15 pages, Los Angeles's is 30, Portland, Oregon's is 17, and that's one that they're used as a model. Santa Monica's is 23, Seattle's is 61, that includes permit documents as well as ordinance, and University Park, Texas's is 12. There was a concern expressed about having companies report usage data, and if they don't have sufficient usage, having the company subtract devices from their fleet. So we do have a provision in 78370D and E whereby permittees have to provide all data the city requests, including real-time data, archival trip data, data pertaining to the frequency and location of trips, customer complaints, device defects, and accident data. We also have 78371B, where the city manager can adjust the number of devices authorized under a permit weekly, taking into consideration device usage, supply and demand, etc. There was a concern about accessing data that companies collect and sell. Now, we should also have access to that data. And I would simply caution that if we collect that data, it should be anonymized and not tied to specific users, because data that does come to us is subject to public records requests. So we would probably want data that is definitely randomized and anonymized and not tied to individual users, no phone numbers, no names, no addresses. There was a question about whether a model ordinance exists. A model ordinance does not exist. The International Municipal Lawyers Association had tried to put one together, but they said it's too city specific. It depends on council members' desires. So a model ordinance does not currently exist. There was a question about docked and dockless devices, whether they should be treated the same. And from a safety perspective, they can be, except when it comes to the regulation of placement, parking, and obstruction of the right-of-way, because dockless devices do expose cities to some potential liability under the ADA in a way that docked devices do not. There was also a suggestion that we consider deducting impounded devices from fleets authorized under a permit until companies pay fines to retrieve the devices, because the company may prefer, if a device is impounded and it's a used device, to abandon the device that's impounded in favor of purchasing a new device. So that is something we plan to incorporate in Section 78371. There was a question about whether we require insurance certificates for docked bikes. And the docked bicycles, as I understand it, go through the encroachment process currently. The encroachment process does require insurance certificates for facilities that encroach in the public right-of-way and for permitted activities by those encroachers. So that is a requirement currently. And then finally, there were some comments about tying scooters to bus stops so that riders can get from bus stops to neighborhoods without having to walk so far. We plan to implement that requirement as well. And there was a question about charging fees per unit, and we have implemented a requirement 78379B, whereby we charge a device fee of $100 per scooter, $50 per dockless electric-assisted bicycle, and $25 per dockless human-powered bicycle. I think that covers it.
Madam Attorney, I think there might be some questions from the floor. I'm just going to start with one. You know that I've been quite concerned about the age limit.
Yes.
And I know that we did lower the age limit from 18 to 16, which makes perfectly good sense because there's a lot of young people who utilize scooters as an alternate form of transportation. Mm-hmm. What should happen if perhaps someone who was a little younger than 16 was found to be in operation of one of these particular vehicles?
Right. So if somebody younger than 16 is in possession of one of these vehicles and it belongs to a shared micromobility device company, then that company's device can be impounded and the company can be charged a civil penalty. We are not currently charging civil penalties to users, and we do not have any criminal penalties in the ordinance whatsoever.
And I think you mentioned in the fee structure conversation, I think there was a fee structure of maybe $150 for a violation and $300 for a violation. What category would this one fall in?
Yes. So this one, bear with me for a moment.
Okay, take your time.
Apologize.
And if that's something you need to get back to us, because we will hold this item in committee, you can do that.
Yes, sir. So the civil penalty is $250 per violation. The impound fee is $50 for every day that a device remains impounded until it is picked up.
Thank you. Any other questions? Let's start with Mr. Larson, Mr. Bessie, and then we'll go to Ms. Scipio.
Well, compliments to the legal staff who are working through this, holding the volume of the document down. Could do a little larger font for us old guys, and need to look at that and boost up the number of pages. I do have some very specific questions, and I'm not sure, Mr. Chairman, I need to go through all of them, but I am curious about a couple of things. One is, I think I was asking earlier about the 72-hour impoundment or abandonment clause and for scooters, and the 7 days for bicycles. And I'm curious about how that's activated and how that's enforced. When does a scooter become abandoned? These things, are we assuming that they're picked up, all of them are picked up every night, and that we go around at midnight and there's any scooters there that it's an abandoned starting at that point? 72 hours is a long time. Are we tagging them? What we actually do to constitute an abandoned scooter? And if we could understand that a little bit better, I think 72 hours remains an incredibly long time, particularly if it may take us a day to figure it out, or a day then to notify them, and maybe a day for them to remove them. And it's still a long time. And I think we ought to look at that. Second point is, I'm not sure what the difference, and you don't have to answer this now, this is my question. I'm not sure what the difference between a bicycle abandoned and why we allow 7 days for a bicycle to remain abandoned on the sidewalks or leaning against stores or whatever these things are, and a scooter. We're saying 7 days for that, 3 days for scooter, 7 days for bicycle. I'm not sure that is equal treatment, quite honestly, for the two travelers. I noticed you're the legal people, but I noticed on page 2 where we talk about defining whatever electric scooter, stand-up scooter, is saying smaller wheels. It gives a wheel diameter of 12 inches, but it doesn't say in line. Have we abandoned that definition as part of a definition for a scooter to be inline wheels as compared to parallel or side wheels?
No, Council Member, we can certainly reinsert that in tandem.
I'm wondering if that's a useful tool as compared to, say, for segways or something we might be dealing with as we go along. The idea then of hours of operation, the asking for actually a storefront or a physical place and a person who's responsible for this, for a program for a licensee to be operating here. I'm curious that the hours of operation for that office does not correspond to the hours of operation for the rental of this equipment. And we're allowing them to start renting them at 6 in the morning and running them till 9 o'clock at night, yet we're saying the office is only open from 8 in the morning to 5 in the afternoon. And I have a little problem with that because probably most of our problems are going to start happening around 8 o'clock at night or 7 o'clock at night, and we don't have anybody really to deal with this unless they have a program. I think you mentioned a hotline, but we need to be clear that the hours of operation correspond to the reliability and presence of that licensee or that company to be able to address problems in a timely manner. We say 2 hours, and oftentimes before we'll start toting, impounding these vehicles. So I think we need to look at that as well. I think that's about all. We put a lot of responsibility on the city manager, and I'm happy to see that change. I think this is still a moving target in a lot of ways, that we're going to be some adjusting of some of the administrative guidelines that will be provided as the number of units, the companies that are authorized, the appeal process for after a selection has been made of possibly 2 vendors, and the idea that perhaps a dispute of some sort would be appealed to the committee. I think that's been addressed, but the appeal out of the committee still seems to be somewhat in question, and I would ask my colleagues to think about what their role in final arbitration of decisions are, whether we're going to leave it entirely to the city manager or whether we want the committee to be the sole arbitrator, and if somebody's appealing the committee's decision, where does that go? Right now, I think it goes back to the city manager. So we might consider whether it goes to this committee or some other committee if there's a legal dispute. Sooner or later, us politicians have got to take some responsibility in this, and we can't allow the city manager to assume all the problems. Those were some of the main points I think that I had, and if there's something else, I'll add to it later as I let others people speak.
And Madam Attorney, the information that Mr. Larson brought up that requires information to be brought back, you can just review the tape, bring it back to us by next month, and we'll get it moving. I believe this is something that we can get carved down for action in March.
Next month.
Councilman Bessie.
Thank you. I think staff did a good job of writing up what we asked for. I had one point. It's on page 13. It's section 78.376, impoundment. Paragraph A talks about the grounds for impoundment, and I think there is a confusing comma that could leave the misimpression, depending on how you read it, that it's only intended to be effective in the formal public right-of-way, and that's the comma after abandon on the second line. I think if you drop that, it would be clear that, you know, any device that's operated, offered, or made available for rent in violation of the article is subject to impoundment, and any device that is stationed, left, or abandoned in the public right-of-way. Does that make sense?
I believe
It takes a lawyer.
There's an attorney. You know how he is.
I can
Great catch. Mr. Bessie, great catch.
Councilmember Bessie's an attorney.
That's all I had. Thank you.
Thank you, Mr. Bessie.
We are detailed.
Councilwoman Scipio.
Well, I'm not a lawyer, but I'm reading this, and it's still, I think it's a wonderful document, but I really, it's just for commercial items, and I don't think it's really clear in this document what happens if a resident has one.
Right.
So, but some of these regulations and rules should be for private citizens who have their kids are riding it, if they're abandoning them on the street. So I'm really not sure that this document addresses that, because I see that as a real problem going forward. You're going to have residents have their little micro, whatever these devices are, and so it comes into how do we enforce them? And I'm also concerned about how our law enforcement officers spend their time on enforcing these rules and regulations. I just have a concern about that. I'm not sure how we ask them to pick up these scooters or things like that, or call it in, whatever, when there's so many other things we want them to do in the community. But I'm just concerned about those kinds of issues, the implementation.
Councilwoman Scipio, I was prepared to address, you know, the privatized use of scooters, but I think it was the request of the committee that we separate the two and then come back at a different time with a separate ordinance. Now, I think that is certainly necessary, because I thought for Christmas you'd see an overabundance of young people out with these scooters, but I think in the future it's going to be a viable mode of transportation, and we have to address it.
Yeah, and I can see the kids just drop them on the sidewalk, but because they're not a commercial scooter, theirs gets to stay. Seems like that's not fair.
Mayor Pro Tem Burt.
Yes, what Councilwoman Scipio mentioned about who's going to be responsible, because to me, we said the last time it would really waste a lot of the police time, and maybe it ought to be a person responsible, not a police, to do that. Have you given any consideration to that?
I'm sorry, council member, whether the police will be enforcing the ordinance or no?
Right.
Yes.
The possibility of maybe having another staff member who's responsible for that, like the regulation of taxi cabs or something along that nature.
That's what we're thinking about.
Okay, great. So we've heard from, well, come on up. Come on up. Oh, we're good? Okay, so we are thinking about maybe a separate officer, not a police officer, but a separate officer to address that, like we do taxi cabs, Mayor Pro Tem Burt.
And also,
I love that, a bird watcher.
and like we do with cars, where you have them going around ticketing, you're not a property place on the street.
Right.
Councilman McIntosh.
Yeah, I know that our city manager is happy to be the point man on this. I know he loves the world of scooters. Appreciate you stepping up to that. I don't have a problem with the length of this ordinance. We are not the only ones who are concerned, and if anybody's going to get out lawyered in this, it's going to be us. So I think we need to be very specific and ask for everything we want up front and work from there. So I don't have a problem with having us what is it, a 17-page ordinance or so. That's fine by me. I like the idea of having them at bus stops. I don't know how we implement that, how we work that in to having them at bus stops.
Yes.
I think it makes a lot of sense. So that's a good idea. What's the primary, I guess, as we went through this, I wrote this down early, but what's the primary reason for us to delay this another month? And I guess there are enough things that we need to kind of come back and refine. I want to make sure that they're out there as quickly as possible, not before we have questions answered, but I want to make sure we get them back out in the streets. 15 miles an hour versus 20 miles an hour. I thought these were limited by the company to 15 miles an hour.
I believe I heard that as well, yes. So our
I don't
ordinance
see
is
any
20
need to
miles
go
an
to
hour.
20. In an urban environment, 15 miles an hour is as good as 20 miles an hour, and maybe we can just increase the safety factor a little bit there. I don't think 72 hours is too long. I think once we get into the swing of this, somebody who sees one abandoned, reports it, when it comes up, and you take that serial number, you get it back to the company knows in 72 minutes whether it's, that it shouldn't be there. So I don't think we'll have that. I don't think we'll have that problem because we're going to be finding them accordingly. I don't know that we need the physical presence downtown during those operating hours. Again, this is a business that operates by data and by cell phone. I really don't know what the physical presence brings us so much. People are not going to volunteer to go do that unless, are we going to require people to go make physical contact with the company before they can rent? So I'm not really sure what the physical presence gets us.
Well, before you speak, Mr. Larson, Mr. McIntosh, have you completed your comments?
Okay. I'd like to see maybe down the road that we allow these on greenways, but I think we have to go through the experience first to see how, we can live with them. The helmets, you don't have to wear a bicycle helmet on after 16. And I think myself, and I'm one other person I've ever seen riding one wears a helmet. I think we're going to be wasting our own time with that. I don't see the reason to do that. My big one is the response to hacking. And that's when this thing really blew up in my mind and citizens' minds. What's in the ordinance that allows us to just pull them if we see that kind of behavior again?
Right, and that's actually one of the reasons I'd like to bring the ordinance back again next month is to make a more robust provision regarding data breach and consumer protection. So there is a requirement in the application process where they have to tell us how they intend to comply with applicable laws, including laws pertaining to data breach. And we make our evaluation based on that. Are we going to give a permit? Do they have sufficient safeguards in place? But there is more that could be implemented.
So the age is the trigger for us, the age of the rider.
Correct.
So if they get hacked and are being ridden by 10 and 12-year-olds like they were, that's our ability. That gives us our ability to go back and say, you're not enforcing the 16-year-old rider provision.
Yes.
Okay. On the insurance front, what do other communities do?
Yes, so other communities do require that they be named, many other communities require that they be named additional insured on the insurance policies. The requirement to have the chargers and the mechanics named as additional insureds on the insurance policies comes from the International Municipal Lawyers Association. And they feel that that's an important recommendation. Now, there are two schools of thought about that, and there's some valid arguments on the other side, too. But they feel that if you're not going to have the subs named additional insureds on the company's insurance policies, then you need to look at increasing your own liability insurance to compensate for that. And, of course, we are self-insured. So,
But Lyme and Bird have seen that requirement before?
I believe so, and that's another thing that I need to do is bring you back a matrix comparing our ordinance to other municipalities' ordinances, including those insurance provisions.
Good. And one last one is, if we see an injury rate spike, how do we deal with that?
Injury rate spike.
Well, I've gotten a couple of.
Yes.
I think it was a New York Times article that got forwarded to me about 40 times that showed a major spike in injuries.
Yes.
Is that? Have we got some sort of umbrella thing where we can just say?
Well, we can adjust the number of devices weekly, depending on public safety needs and other factors. We can also revoke and suspend permits if we decide that it's no longer in the public interest.
But that's built into this ordinance.
Yes.
We would have that ability.
Yes.
Okay. Thank you.
Yes, sir.
And it's my understanding that this committee also has the ability to revisit the concept if it starts to get out of control. Members of the committee, we don't want to belabor the hour. We have a fairly robust agenda. Mr. Larson, you wanted to be heard briefly, so we'll let you
Thank you.
Okay, if we keep it brief, we've got two.
Thank you. Let me just respond. Quick question. Are we requiring a North Carolina driver's license to ride one of these things?
We are not. I believe the companies do. I think it's in their terms of use,
Well,
but I
that's
can
what I'm
check on
asking.
that.
But it would be a requirement. It's all safety rules, driving responsibilities, all of that of North Carolina highway laws would be a part of anybody getting on one of these vehicles based on the company that currently operated here.
Yeah, so I believe that the companies themselves are requiring the driver's licenses, and then our ordinance says that users have to comply with all applicable safety
Safety laws.
traffic laws.
So we would assume that that's applicable. Regarding, I mean, my concern regarding the hard office or accessibility really is responsiveness of the company to be able to address violations or concerns that arise. Now, if that's done electronically, that I'm certainly willing to consider that. I'm saying an abandoned scooter is found at 6 o'clock at night, sitting on blocking some sidewalk. In violation, the choices are going to be to somebody to tow it or seize it. There's nobody coming in the office until 8 o'clock the next morning. It's unlikely that it's going to get corrected unless there's a mechanism to actually report and have that vehicle corrected. And that's the main question. It's just because the office is closed does not mean the responsibility goes away.
That's right.
So if they are operating from 9, basically from 8 o'clock in the morning, 6 o'clock in the morning to 9 o'clock at night, whether this be bicycles or scooters or what have you, that there be somebody accountable during all those hours of operation for the conduct of that vehicle.
May I say something on that? I'll agree with
Mayor Pro Tempest in order.
because even before they pick them up, we could go through neighborhoods and see them right in the middle of the sidewalk. Children have to walk to school. A lot of people walk nowadays, so I think that needs to be addressed, and I think it's too long. I mean, waiting so many hours before you could do something.
Yes, ma'am. Last word goes to Councilman Bessie.
Thanks. I just wanted to make a note, because Councilmember Scipio and some others had raised the question of applicability of some limits, some restrictions to privately owned device. There actually is language in the first paragraph of the purpose and scope that specifies some specific subprovisions of this ordinance, especially regarding use or abandonment of scooters that would apply to privately owned. It's just a matter of what you can collect them for if they're out doing wheelies in the middle of the intersection or something like that.
That's correct, Councilmember Bessie. There are some provisions of the ordinance that do apply to privately owned devices still. Public safety related requirements, so helmets, where you can use them in the public right of way, not on sidewalks unless you're walking them, to retrieve them from the sidewalk or to park them on the sidewalk, and violations of all those requirements are subject the offender to impoundment of the device.
There's so many pages of information here that I know we can talk about this all night. And if we don't move, we're going to stay here all night. And I know that we got a room full of people that want this agenda to move forward. So, Mr. Larson, when I give my word, I keep it, and everybody knows it. I'm going to go against my word. Now, my kids will be shaking their finger at me right now.
This is a technical error regarding the lights on the night travel on these vehicles.
Yes.
Your technical error, you're showing a white light on both the front and the back. I think we talked about a red light on the back, but I would add also that they should be visible from the side as well as from the front and the back. That as you're going through an intersection, you need to have visibility on the side as well. So whatever the instrument is, like in cars, you can see red lights on the side of the car. Thank you, Mr. Chairman, for that opportunity.
Thank you, Mr. Larson. Madam Attorney, thank you for your time. We appreciate your hard work on making this an ordinance that's palatable for all, and we'll see you next month for action.
Thank you.
Thank you, ma'am. Item G2, please.
G2, consideration of amendments to the abandoned, junk, safety, and health hazard vehicles and vehicle impoundment codes.
All right, there are several different departments that have collaborated to make this happen. We'll just start with our city attorney's office, assistant city manager, city manager's office. Assistant city manager Ford, you have the floor.
Good evening, Chairman Taylor,
Good evening.
Mayor Pro Tem Burke, and members of the committee.
Good evening.
We started looking at some of the problems that we were running into with towing vehicles, really with our current lot being at capacity. This has been a problem that we've been addressing for a couple of years, and staff started looking at alternative options. We started looking at whether or not it would be feasible for us to lease some additional space, but prior to doing that, wanted to make sure that we brought this item before you so that council could understand the situation that we're in. After looking at how other cities handle the storage of vehicles that are towed, there's some policy recommendations that we want to bring before you this evening for consideration. Our recommendation would be that we look at changing our current ordinance and our practice to be more in line with what our peer cities are doing. So I have our Deputy Director for Community Development, Sharon Richmond, will present to you operationally how we handle things in community development. We also have Captain Cardwell from the Police Department, who will talk about how the Police Department handles things. And then our Deputy City Attorney, Mr. Andrews, will actually go through the ordinance changes that we would recommend. After we get feedback from council, our plan would be to bring this back as an action item if this committee desires. It's also being presented to the General Government Committee on Tuesday as well. So with that, I will let Ms. Richmond and Captain Cardwell kick off the presentation.
Okay, Ms. Richmond, Captain Caldwell, who will be going first? Captain Caldwell, you have the floor, sir.
Good evening. As Mike Cardwell, I'm a captain over our Support Services Bureau. Good evening, Chairman Taylor, Mayor Tipor Burke, and council members.
Good evening.
We're going to talk with you with just basically some information that supports from each one of the departments about why these changes are needed. At the end, we'll give an opportunity to talk, but I think both of us kind of handle different portions of why we're in support of it and that it's needed. Currently, City Code allows the police department to remove unattended vehicles that are obstructing traffic, blocking alleyways, driveways, and otherwise impeding fire services. Likewise, City Code authorizes community development to remove abandoned, junked, and safety hazard vehicles. We both share a facility on Milwaukee Lane 4011 and have shared for several years now. The lot is currently divided into two separate storing areas. The police department lot has a capacity of 135 vehicles, while the community development department has a capacity of 144 vehicles. Excuse me 1 second. We got off slides here for a second. Over our operational years, we average the police department the seizure of approximately 120 vehicles, and we maintain approximately 200 vehicles as evidence at the facility. So we've grown past our lot storage space. Community development has allowed us to utilize their space as kind of a buffer or overflow area. In addition to those vehicles that we seize, we average an additional impounding of 141 vehicles that are towed to tow lots and eventually would return to our lot under community development when they're not claimed by owners. In addition to those vehicles, we also turn over about 56 unclaimed vehicles that may be evidence at one time or were seized for some reason. So you can see that there's a lot of vehicles that are running through our storage facilities. So as a temporary fill-in, in 2017, both lots were completely filled. We unfortunately had to start using off-site storage. This predominantly for the police department was the tow companies themselves. For non-evidentiary vehicles, we would store those vehicles for longer terms, past 30 days, until we had space at our lot to fill. In 2018, this incurred approximately $50,000 in additional fees for that year for storage and towing associated with it. It should be noted, though, that if the Winston Police Department was a sole user of our Milwaukee lot, that would meet our needs operationally now and would give us room to grow in the future should we need it. So to fill in additional information in support of this, I was going to hand this over to Deputy Director Richmond.
Dr. Richmond, you have the floor.
Good evening, everyone.
Good evening.
So to start with the code enforcement slides and to give you some background with code enforcement, the initial process that happens in code enforcement, a complaint is made, whereby the code officials go out and respond to that complaint if a violation has taken place, because in some cases we don't have violations when we're going out to look at vehicles. But if a violation has taken place, the vehicle is cited and has 7 days to be removed by the vehicle owner. The code official escorts the towing company to the lot, because that lot has to have a code for any of us to access it. So the police department, of course, and code enforcement has the access to the lots. Each tow is $75. The code officer gives a tow ticket to our administration staff, and then we have at least no more than 3 days to issue a post-tow letter to the vehicle owner. One of the processes that we do in code enforcement, for code enforcement side as well as the police department side, we perform the auctions. Community development car auctions are a 3-day process. 5 auctions have been held in the last 2 years. Auction day typically involves all code officers and 2 administrative staff folks. The following 2 days are vehicle pickup, where we switch out code officers to wait, so all the folks who have purchased vehicles will have an opportunity in the following 2 days to pick up vehicles that they have purchased. All funds from the auction are given to the financial administrator in our department, and that is deposited in, I believe, revenue. In 2016 and through 2017, we had 28 cars towed. 2016 to 2017, 45 cars were towed. 2015 to 2016, 60 cars were towed. And in the last 2 fiscal years, we've only had 2 citizens to reclaim vehicles. Recognizing the recurring problem that we have with the excessive demand for both the police department as well as code enforcement to use the lot, CD has yielded on a couple of occasions to make sure that the police department had enough room. CD started the process of investigating alternatives, and one of those involved checking with surrounding cities that we have. Charlotte, Gastonia, Raleigh, Greensboro were some of the cities cited. Each of these cities contract towing companies for removal of junked and abandoned vehicles, so they do not actually have lots in those communities where they are holding vehicles. And this page that you have is very difficult to see, but that actually shows the municipality, how they receive their complaints, and we just ask them the same questions that we do in our process to find out what the differences were. But the main difference is that they tow, or they have their towing contracted to, I guess, towing companies.
And could you read those cities, please, because we can't see them?
Yes. The city of Charlotte, city of Gastonia, city of Greensboro, and the city of Raleigh.
And they all contract their towing out to someone else?
Yes, sir.
Okay.
This is just one of many pictures that we have. Sometimes the lot gets a little bit more full than this, and when that happens, we have had a few incidences where, based on wind, rain, ice, and snow, we've had vehicles to actually run into or slide into each other. And in summary, what we have come up with is to eliminate city involvement in the vehicle storage could save money for the city. Elimination of auctions, reducing staff time with vehicle research, and that research also includes working with NCDMV, which has to clear the vehicles that we are allowed to auction, and that process can take at least a month. It averages a month. And then streamline the process for customers to come to one source to reclaim their vehicle. That's what we've summarized that would be a benefit for the customers as well as for the city. So I will turn this now over to Mr. Andrews, who will talk about the ordinance revisions.
Okay. Attorney Andrews?
Chairman Taylor, other members of the committee. As a part of attempting to effectuate the changes that we felt were necessary to our code in order to reach our goal, we had to kind of go through the existing code provisions that we have and make suggested changes and amendments. And our code has a section that relates more to the police department. and then has a section that more relates to the kinds of tows that the Community Development Department, their code enforcement division, enacts or regulates. So what you have loaded in your system are proposed changes, and I'll go through as quickly as I can highlights of some of those provisions, and we can talk in detail if need be. As part of any kind of looking at code sections that need to be upgraded, we do note sometimes some dated language or technical changes, and at the very beginning we had a provision that we found that was dated regarding no parking downtown after 1 p.m., so we deleted that, and another one that related to an older provision of the code for a name for the fire department. So we changed that. Getting into the meat of things, the way I've kind of got this set up is provisions that are going to be removed and provisions that are going to be added. A concept that you will see here now as changes that are going to be duplicative, but I'll mention them in the beginning, is we are moving from the model which we have now, which is the city calls for tows, and tows are made by tow companies, and the vehicles are then towed to our storage lot, to a provision where private towing companies are really going to be taking a lion's share of the work. They're going to be called by us, they're going to tow a vehicle, they're going to store that vehicle at their premises, and the vehicle will be available at their premises for being claimed by vehicle owners, and transactions will occur. The city will be able to retain an administrative fee of $60 per tow in order to recoup some costs that we have made. What we had done previously involved a hearing that was allowed within the city, separately from any other hearings. We're going to eliminate that procedure and go to what the statute has. So with that being said, I'll kind of go through. In the second section of the bill, the vehicle owner's right to request a hearing internally has been moved as we slide over to having that be per the state statute and having that done before a county magistrate, and the provisions for all of that are contained within the state statute.
Mr. Andrews.
Yes, sir.
Before we move past Section 2, it may not be very important to many people. It's important to me. Just something, a quick adjustment. 2A says it shall be the duty of the chief of police or his designee to notify the owner of any vehicle impounded under the provisions of this article as follows. Well, we have a woman chief, and I want to make sure it's either her or his or her. Let's be sure we
Absolutely.
keep our eye on that. Yes, ma'am.
Absolutely. Thank you very much, Chairman Taylor. Appreciate that.
All in the detail.
Yes, sir. Some of the language in legislation in our codes has a single gender, so we certainly understand that. Currently, under our current provisions, we have a towing schedule that has an elaborate setup of costs and fees for the cost for towing, the cost for special tows, the cost for storage, and all of that. As we're moving forward, our proposal is that with the private towing companies coming into play, the fees will be set market rates by the private towing companies, much as a regular tow would be for a citizen, and we're stepping away from regulating that. So you will see as a theme as we go through this where we have eliminated the tow schedule that we had, and we're going to a provision that will allow for either a market rate or rules and regulations that we'll create as we advance forward with this. There was a case that went through the North Carolina Supreme Court called King versus Chapel Hill that dealt with an aspect of towing primarily from private lots. But the town of Chapel Hill instituted a cap for towing fees in that case that was essentially overturned by the courts. And we wanted to steer, even though our fact pattern of what we're doing here is a little different, we wanted to steer clear of any concerns for that. So that was another reason to step away from having within our code a fixed tow cap or tow fee schedule. So that's why you will see it eliminated in the proposal that's before you. What it does allow for is for a rate to be set, and again for our retention of our $60 administrative fee, and that's what's contained in the proposal before you. Also, when we reviewed and looked at our current schedule, we had an additional category of vehicles that could be towed, and they were health hazard vehicles, and they had separate provisions. It was determined when we looked at the totality of our codes that that category was not necessary to be kept and set apart. So we tried to condense and clarify, and we still have sufficient coverage of all the provisions of what we do have now. So we've simply removed the term health from the title and So the title to the new section will reflect that removal. And in moving forward, we will remove references to that provision there. In the fifth section, there was previously a provision that allowed for tows to be made from private property. So a private property owner could call for an abandoned vehicle tow on his or her property when a vehicle was parked there without consent. We are getting out of being intermediaries for what we sometimes refer to those as indemnity tows, because the private property owner would have to sign an indemnity agreement for any damages. We're getting out of that towing at the request of private property owners. They can still request those tows when need be, and we're simply stepping away and making that not be available through us, but still being available in the market, if you will. In doing so, we needed to change and modify some of our definitions. So in Section 5, we adjusted the definitions to account for that eventuality, and you'll see that there. We've also put in place a new term that was not previously in our code for private tower. That simply identifies that private towing companies will now be a part of our scheme, and we've created a definition to simply give them a definition, because that term will be used throughout going forward. In the next section of the bill, we removed certain sections, as I mentioned earlier, that dealt with indemnity tows, where we have different themes that go through our city code sections, and we are coming to each section where it appears and adjusting. And here's another adjustment. We have also recognized that we don't have this additional internal hearing, pre-sale hearing, that we're going to go with the formal hearing procedure that's available through the county. And we're also removing the city being the seller of unclaimed vehicles. You just heard a presentation where some of our challenges are because unclaimed vehicles sit in our lot, they accumulate a lot of fees, and then we go to sell them, and very rarely does the owner of the vehicle come to pick that vehicle up. They're simply auctioned. We're getting out of that business, and now private towing companies will be sort of standing in those shoes, and they will be taking place in doing that. In Section 7 of the new bills, in Section 7 of the amendments, you also have some additional provisions. We are adding provisions to clarify that vehicles can be towed at the city's direction, but they are not being towed by the city. They're being towed by private vendors. And we can still, while we are not towing at the request of a private property owner, vehicles that are abandoned on private property, we still retain the ability to tow safety hazard vehicles. So if a vehicle has been determined to be a safety hazard vehicle, that vehicle can be towed from that private property, just like it was an abandoned or junk vehicle that was in violation of our statutes, of our city ordinances, that is. The probable cause hearing that previously existed within the city, again, is going to be done by the county. When a private towing company does tow a vehicle and sells that vehicle because it's not been claimed, any surplus that is recovered from that sale above the amount that is owed for the towing and storage is returned to the vehicle owner, and if that vehicle owner can't be ascertained, it's given to the court and it can be claimed later. Further, there are some provisions that are being added in Section 8. The procedures for post-tow pre-sale probable cause hearings that I have mentioned to you before are now mirroring what is available and are required by state statute. And so we have taken and we have made direct reference to the state statutes in Chapter 20 that govern that, and we have placed that in our code so that we are in keeping with the state scheme that's available and making sure that what we do is being followed there. We do retain a burden to provide notification to vehicle owners. So if we do call for a tow of a vehicle by a private tower, it is the city's burden to make notification to the owner. And there are time periods that exist in state statute that we will follow. So 24 hours for an in-state registered vehicle and 72 hours for a vehicle that's registered out of state. And we use our due diligence to make sure that the owners are notified of that. Again, because we are now dealing also with the section of towing that involved a fee schedule for community development code enforcement tows. There was another fee schedule that existed in our code. We had one specifically related, as I spoke before, about police-initiated tows. We have one for community development-initiated tows, and we have made a mirror or essentially the same change there and stripped out those that fee schedule, those fee caps, and put in place a provision that the towing rate will be what the market dictates for the private tour or what rules and regulations we put in place, but retaining our ability to have the $60 administrative fee to defray some of the expenses that we will incur by searching and seeking out. Unfortunately, we do come across vehicles that are very difficult to find the owner, and we have to engage in whatever is required to try to do that as best we can, and we do incur charges for that. So that will be able to be recuperated. And then finally, in Section 10 of the ordinance amendment, we have to go through this as administrative. We have to remove the health hazard provision that was listed in a list in the existing code language, and we'll remove that. And Section 11 is finally that it'll be effective upon your ratification of it, and that will be the date. So that's a quick sweep of the changes, but again, the unitary purpose is to remove our burden of storing these vehicles and selling them, which were two pretty significant burdens on our part, transferring that to the private market, but allowing us to still have the flexibility to have vehicles towed when they need be. And of course, space is magnified because now the vehicles are being stored at private tow lots. So with that, I'm glad to answer any questions that you may have about any of that.
Mr. Andrews, in order to increase efficiency and effectiveness, this certainly makes sense to me. I think it's important that we move forward with it. This is just an informational item. Are there any questions the staff needs to hear so they can bring back? So we'll start with Councilman McIntosh.
I drove it to truck in high school. This makes a lot of sense to me. That's what we did. There was no city impound yard. You brought it to the station. Sometimes you had to block it in with a car. We're afraid of somebody stealing it back. But so in other communities that do this same thing, that have stripped out the fee arrangement, the experience has been that those fees remain fair. I have a little bit of agita about that,
right,
about tow companies, sensing an ability to run roughshod over folks.
Very good question, Council Member. You see different methodologies applied in different cities. So some have a market rate that is open in the market, and the market will bear what people are willing to tolerate. There is at least one city, Durham, that has a set of rules and regulations that features a rule-based cap or a policy-based cap, but not a code section cap. That's a method they chose for police towing that is capped at a certain amount. Again, whether you want to engage in the cap depends upon your risk tolerance for concerns about legal situations. I mean, I think our towing that we're looking at doing is a little bit different than that in that case. But there is the possibility, and we would need to caucus and determine what's the best way moving forward to put in place a scheme, whether we allow purely it open to the market or whether we look at trying to place some boundaries to that.
And if we go market rate and find that there's a problem, we could retreat to that, or we could come back to that as a second option to revise the ordinance.
Yes.
Okay. So how does the process go? I may or may not have had a car towed once in my life. So car gets towed, somebody comes back and says, my car's gone. They're immediately going to call the police, I would assume. And the police will have that information on hand. They'll know who towed it, where it's located, and they'll pass that information on to them.
Your question makes me think of a vehicle that's, say, parked illegally or somewhere it shouldn't be. And those kinds of vehicles are often involving the police-initiated tow procedure for a vehicle that's blocking traffic or stay too long under a meter or hadn't paid parking tickets. And you can call the police department, and I believe Captain Cardwell can address how that's happened and as he comes forward.
But from our experience, that's a very low percentage of what we deal with.
So in those circumstances, an officer would respond to the location or would identify a vehicle that needs to be towed. The officer will do his diligence to first try to locate the owner themselves. So that's our first line of that the officer is going to research through our records, DNV, try to find phone numbers. We want the owner to move the vehicle. We don't want to tow it. Right. That was what it comes down to. Once the vehicle's towed, the officer writes a report, it goes to our property or evidence management section. They again go back through identifying the owner, trying to research to get a hold of them. We start the letter notification process that's been towed. All of this during this process is documented electronically, so if I were to call in about my car and I said such and such vehicle with such and such registration, we would have that in our report system that night, so it would be easy to identify.
Okay. And then, what was my last question? Oh, alleyways. Abandoned car in an alleyway. What's the procedure for a neighbor saying, I want that towed, and we tow it? Is that fair game?
So when you deal with abandonment, we do stickering of vehicles that are abandoned. Typically, it's a 7-day window of time when we sticker, so we get it. If it's blocking traffic or something, we can move it quicker because it's a hazard vehicle, a safety hazard.
Right.
So if it's a safety hazard, it's quicker. If it's just abandoned on the public streets or somewhere like, we have a waiting period in where we sticker the vehicle.
Great. Thank you.
Mr. McIntosh, I think you bring up an interesting point that I had been considering. I don't know that I like the idea of the market dictating the price of the tolls. I think there's some people who are doing really, really well in this economy. There's some people who are not doing very well at all. I mean, I personally know people who would love to have a license. They can't have a license because they have so many fines accrued to them, they just can't pay it. And so to add another undue burden for people who, I mean, the definition of a junk car, one of the definitions is more than 5 years old, or, you know, something that's worth less than $500. I mean, so we aren't talking about wealthy people. Well, mine too, but we're not talking about wealthy people here. We're talking about people who probably need a break. So I'm a fan of a cap, just considering, you know, the people who we represent on the whole entire spectrum. I just don't want the market to run away. We have a responsibility to protect people and to serve them. And in regards, so I think we ought to cap it. But that's just my opinion. We'll discuss it when it comes back. We'll go to Councilman Larson, and we'll come to Mississippi.
We've just spent a lot of time licensing scooters. You know, somebody's got to make a call. Somebody makes a call, got a problem with a car, got to get it towed. Usually that's either a bar owner whose car is parked out in front of the bar and they want it towed, and that's on private property. We don't worry about that. We have a property, or we have a car that's parked on city property or public property, needs to be towed for one reason or another, not tagged, it's abandoned, whatever. Somebody makes that call. Usually comes out of the police department, I assume, because that goes to CD or goes to whoever, and they have to make a call to a tow truck company. And what tow company do they choose? And so the question ultimately comes down is, what are the qualifications of that tow company to perform the duties that the city's currently doing, and what are the charges that are being generated by that tow company? We have a contract, more or less, the city's entering into an agreement now where we're sending business to a private sector. Right. And we need to be clear that that private sector is not taking advantage of individuals. So I think that's a question we need to sort of work through as we look at how we privatize, basically, a function. I also assume that this does not apply to evidence vehicles or police seizures, and that those vehicles will remain still towed privately, perhaps, probably. It seems that's the way it happens now, but those are not going to go off to some junkyard somewhere, whatever, that they're in fact going to still be contained and controlled by the city. We will still have to dispose of them at some point in time, or whatever happens to them. So I think it needs to be clear that we're not entirely privatizing from an enforcement perspective vehicles of crime. And I don't know how many of those are, but it seems to be a substantial number, what it sounded like annually, that we're still dealing with. So I would like, I'd like to spend some time, obviously, thinking about that. Now, the issue of non-owned vehicles on private property. If somebody comes to my yard and dumps a vehicle in my front yard and says, good luck, I wake up one morning, there's a junkyard sitting in front of my house. What are my recourses as a private citizen? And right now it sounds like, I can call CD or firstly I'd call the police and say, somebody's dumped a car in my front yard. And then they're going to say, well, have it towed away, and I guess that's what I do now. Is that what happens? The police make the call, or, we're talking about basically litter cars here that are dumped on, abandoned.
So Councilmember Larson, heretofore, a person in that particular situation could request what's called an indemnity tow, and they pay the tow company, but we would facilitate making that arrangement, and if the vehicle, was technically abandoned by our definition, but we were involved with the private tow company would be towing that vehicle, and we would end up holding that vehicle in our lot and then trying to recoup on the back end, like for many of these cars.
Right.
And so we're simply trying to get at, so the person still has an ability to have that vehicle towed if it's there without permission.
Who pays for that tow now, and who would pay for the tow under the proposal? Who pays for the tow currently, and who pays for the tow under what this ordinance allows?
Well, currently, the property owner was paying for the tow, but not the storage, because you pay storage when you claim it.
Right.
So going forward, I would suspect, and these rules haven't been fully put in place, that still the tow company to respond would require some payment from the person requesting the tow, but that person requesting the tow would not be paying any storage. It's not their vehicle.
They wouldn't get reimbursed for the tow, though, if the car was sold?
Well, to my mind, it's like a tort. It's like a person has committed a wrong on your property and it costs you money, and you have a claim against them to recoup that money. But we'll look into it to see if we want.
We're looking into protecting the property owners who are exposed to having to have vehicles or stuff removed. I mean, we have the same problem with trash and litter being thrown out in people's yards, and they're responsible. Same thing with graffiti. You have to pay for the cleanup. I understand all of that, but I do think that we ought to assure that whatever money is recovered from these vehicles go to compensate, obviously, the storage, but also the towing charge, having the vehicle removed.
And Attorney Andrews, one other point that Councilman Larson brought up, if you're looking for direction as to how we want to move if we approve this ordinance, we're privatizing this system. I think it's important to make sure that everybody gets a seat at the table. So we don't want one tow company to be chosen over another. And I don't know if we do it by corresponding day of the week or some other operational list where we call them based on, like you would see taxi cabs outside of a hotel. But we should be systematic.
So one of the things, this wasn't mentioned, I'll just mention to you, we now have a record, we have an agreement with the Wrecker Association that's similar to a rotation record contract, and there's very tight specific requirements to be able to tow vehicles so that you have the wherewithal, the means, the storage area, the vehicles to do the towing. And there is a mechanism in place so that new companies can get on that list. But it is by the Wrecker Association. Going forward, per your direction, we might be backing away from a specific contract to do that. But in turn, when we are doing the calling, we would in place provisions that as long as you meet the requirements to safely and efficiently tow vehicles, you can tow vehicles. There's going to be no filter or check or dues to an association or other gateways to penetrate to be able to tow vehicles. It's broadly open, and we would ensure that entities that are capable are able to do it. So we would be very wide open as long as you're capable.
Cost competitive, please.
Yes, sir.
Cost competitive. It's incredible, particularly if you're making that cost transferred to a private individual.
Councilwoman Scipio.
Yes, you've actually spoken to most of my concerns. One was that we would have an approved list of towers who would be eligible. There are a lot of people, well, there are some people I know who have tow trucks. They may not be with the Wreckers Association, but they can give you a real good deal to move your car.
$35.
But that's the kind of thing how we can make those with the entrepreneur spirit legitimate. And I think that would be great. My concern initially is that I heard that very few people have come back to get their abandoned or junked cars. Right. But I do know a situation where a van was towed in, and when the owner went to get it, they did not know that their car had been towed in because they had lent it to a friend, and when they went to find their car, it had been stored for a significant length of days, and it was $1,000 in storage charges. And so I think this is a great idea to make it not the city service, but I want us to make sure that these tow servicers and storage people don't gouge folks.
Agreed.
And that they don't hold it, two things. They don't sell it quickly because it's a great car and they can sell it to themselves. But more importantly, that they don't just have storage charges accumulating, and people then can't get it back. So with this system, we will no longer be in the auction business, and therefore we won't recuperate any funds in that area.
Lots of money there.
Yeah, but we'll get $60 per tow. Is that what that sounds like?
Councilmember Scipio, yes, and if I might just address a couple of things that came up. So there's going to be notice given fairly immediately to the registered owner of the vehicle. So as long as, in your scenario, the person had the vehicle registered, they're going to receive a notice in the mail that says, hey, we have your vehicle, or the tow company that your vehicle is being retained, so you need to come down and get it. And you have an opportunity to come before. People who tow vehicles are not allowed to bid on those vehicles, so you cannot sort of sell a vehicle to yourself by statute. The tow company can't. Okay, well, but yes, sir. Yes, ma'am. Yes, ma'am. So those provisions are there, but we will be mindful as much as we can in the rules and regulations that are developed to be on the lookout for gouging and behavior and trying to deal with that as best we can, as well as making it available broadly to people who have the physical capability to do towing. I know one of the examples that was given was somebody who might be doing towing with non-registered or vehicles that maybe not designed for towing, and we probably won't be calling on companies like that.
Makes sense. So I'll say to Deputy Director Richmond, to Captain Cardwell, to Attorney Andrews, thank you, and all of your departments for your hard work on this. I think it's certainly something that we want to move forward with. If you'll bring the information back at the appropriate time next month. Last word goes to Councilmember McIntosh.
Just real quick, we're not talking about changing the roster and the way that works of people who tow. And we have a system right now that works pretty well, and we're not talking about radically changing how the list works, who gets the next one up. So we're not going to be looking at a system where there's going to be favoritism towards one or the other. It's generally considered to be a fair.
Correct. We want to remove any favoritism.
Yeah.
Right. So that was the last word 1A, last word 1B, the last word 1C.
All right. One quick question. There's a fence line between CD and police department currently in storage, and I want to be clear that the police department has access to any vehicle that's seized in this city, regardless by who does it. That they need to be able to know that whether a vehicle has been stolen and they hadn't picked it up yet as stolen, whether the drugs in that vehicle or whatever, that there's a process in which any vehicle that comes onto this process, if it goes into a private lot, it's not the same as us controlling that vehicle on our city lot. So you have access to all the vehicles right now. I don't know how access you will have if they're scattered around in 3 or 4 different tow companies.
And just to briefly talk about the towing association, they do know our intentions, and they do know that it's in line with other cities. I can't say they're supportive of it, but I'll say that they are aware of it. They are open to us visiting any of their lots at any time. As a matter of fact, we have a designated personnel, a corporal that's assigned our PSD, our Professional Standards Division, that inspects the lots to make sure that they're in compliance with their vehicles, the tow companies are in compliance, to be part of that association.
And just, Councilmember Taylor, I'm sorry, just a quick, now we don't search vehicles that are towed administratively, just police vehicles are searched.
I understand.
Okay.
But things come up after vehicles are towed that we realize weren't applicable when we towed them.
Sure.
Thank you for clarifying that, Attorney. Councilwoman Scipio.
Just to sum this up, this is adopted at a future meeting. In essence, the police department would then have total access to the site, the current site, for vehicles that they tow for evidence.
That's my understanding,
Right.
Captain.
Yes.
Yeah. And
The full capacity of the facility is 279 vehicles. That's both sides. We average about 200 vehicles consistently as we seize them and then release them. So that would meet our needs right now. And for several years down the line.
Thank you, sir.
And secondly, the wonderful community development department would then be out of the picking up abandoned vehicles business.
Lord willing.
Right? Good. Thank you.
Thank you for your time. Thank you, Mr. Andrews. Move to item G3, please.
G3, request to apply for participation in the 2019 Watch for Me NC program.
All right. And we want to give it to Assistant City Manager, Mr. DeCane. If you want to cue this up, please, for Mr. Burchett.
Certainly. I'm just going to introduce him. Matthew Burchick is going to give you a quick rundown on this grant opportunity.
Thank you. Mr. Burchett.
Thanks, Mr. Chairman, and good evening, council members.
Good evening.
We are requesting authorization this evening to submit an application for the Watch For Me NC program. Watch For Me NC is a program operated by NCDOT, a safety program that they began in 2012. Excuse me. The goal of the program is to reduce injuries related to bicycle and pedestrian crashes with motor vehicles. So lately, Vision Zero and other efforts have been in the news. This is comparable at trying to reduce those types of crashes that lead to injuries for vulnerable street users. So there's two elements to the program. One is an education component. There's a heavy education component to this, and we would be providing education for drivers, for cyclists, for pedestrians. And the second component is an enforcement component. So our law enforcement officers would receive training through the Watch For Me program, and then we would operate kind of high visibility traffic enforcement programs for not only cyclists and pedestrians, but drivers who are failing to yield to both of those users. So if we are accepted into the program, we receive print materials and advertising, law enforcement training, an action planning workshop, participation in that workshop, free media support, and then technical support on the kind of the engineering and planning side of things. In exchange for what we receive, we would be required to have our law enforcement officers participate in the training, naturally, and then we would have to conduct some of those law enforcement operations. So back in 2016, we did something comparable where we worked with the police department to have some high visibility enforcement of drivers failing to yield to pedestrians, especially in the downtown area. So it would be efforts similar to that. So really supporting efforts that we are already undertaking and providing more resources for those. Like I said, we are required to participate in the action planning workshop. We would be using and distributing the materials that they have, flyers, educational materials. They even provide bicycle lights. So if cyclists are out at night, not using the lights that they are required to use, our police officers could distribute those lights to them. And then at the end of the program, we are required to report our efforts, how many enforcement periods we had, how many media contacts we had, how many customer contacts we had, so that NCDOT can kind of refine their program and gauge the success. There is no financial commitment to us besides that staff time. There is no financial commitment. We would be involved as staff. And it's a short time frame, so applications are due March 1st. We will know by April if we've been selected, and the program will wrap up by the end of the year. And I'm happy to answer any questions.
Mr. Burchett, any questions? Councilman?
Just great, and go for it. Is this applicable to the interface with scooters as well?
I think
I probably will be.
Yeah,
Yeah, exactly. Yeah. No, do we need a motion for approval on this?
Yeah, well, are there any comments? No, this is an action request.
Actionable.
Okay, we'll go with Councilmember Scipio, then we'll get a motion on the floor.
Although I think this is wonderful because we're gaining so much. Do we have any idea how much, if we had to put a dollar value on what you get out of this, what we would be receiving as a community in terms of the training, in terms of the media support, et cetera?
I do not, but I can certainly ask NCDOT if they have a value placed on that.
And if this item passes, that's maybe information you can get us before we vote on Monday as a full council?
Sure.
Hopefully we save some lives.
Hope so. Thank you for your work on this. Members of the committee, is there a motion on the floor?
So moved.
Second.
And it's been properly seconded. All in favor, please vote yes. Opposers likewise. That seems to be unanimous, so this item will move forward to Monday's meeting for the full council's consideration. Thank you. Our final item on the agenda is item G4, please.
G4, information on urban hunting opportunities. This item was continued from the January 14th, 2019 Public Safety Committee meeting.
Thank you. I was going to jump right into it, but I think Mr. McIntosh needs to leave for a moment, so we'll just queue up just a brief presentation just to refresh us on the concept, and then we'll try to move forward to get this towards an action item today, or at least for next month.
Yes, sir. Good evening, Mr. Chairman,
Good evening.
member of the committee. Previously, we had a citizen come before us requesting requesting the committee direct staff to look into potential urban archery season here in Winston-Salem. So staff has done that. Last month, I was before you and answered all the questions that were presented by the committee regarding other communities, et cetera. And basically where we wound up was with a couple of items within proposed ordinance language. So here's a map that I showed you that has properties larger than 1 acre within the city limits. Important, elements of the map are hunting on from or across public right-of-ways, schools, any type of public land is prohibited. One of the recommendations that was made by the committee was, well, if you just went into GMA 3, how would that look? So the map on the screen right now is properties larger than 1 acre. That blank section in the middle there is where GMA 3 is excluded. So I'll just roll through these maps real quick. You can see there's 2 acres and there's 3 acres with GMA 3. I'm going to drop this down 1 second, and I'm going to open up a few more maps. So knowing that you'd want to see more maps, let me, I don't know why that's not showing up on the screen there. Should pull it up. Still has my, well, at any rate, I can't get it to come up. Essentially, if you add GMA2 in, what that is urban residential zoning, and it would include everything but the business improvement district and the historic districts. And I didn't have them in the presentation, and I can't get them to. Dana, any idea why these maps won't come up? Wait, there we go. There's something's happening. I shrink that down. Why isn't that showing up? I don't know either. I can get them to you, but essentially it's the same map. And I may have misled the committee last month where you have a feeling that this map would show you that these are areas where you can hunt. In most of the other communities that have urban archery season, they have a map sort of like this where it represents areas for the potential of hunting because you have to have the landowner's permission. And it's only representative because if you say 2 acres or 3 acres, most communities have said, or a combination of properties that border each other that equal 2 to 3 acres. So I'll go back to my original map in the presentation. It's frozen up. It's not doing anything now. So at any rate, that's what I'm proposing. I'll be happy to send you the maps that include GMA2, essentially. They exclude the historic district, the business improvement district. And the only other item really to discuss is a limit within the property itself from adjoining properties, say 100 feet, 200 feet, 300 feet, where hunting would be excluded. And I think at that point, the city attorney and I would be ready to bring ordinance, an actual change of the ordinance as an action item.
Okay, so I just want to just brief everybody as quickly as we possibly can. We've had ample discussion about this in committee. I think overall there were members of the council and committee who spoke in favor of this ordinance because it creates jobs, maybe in packing and processing the venison, and then it provides a healthy source of foods for children and families, and then lastly, it can help to feed the homeless and some of the residents in the city who may be living in poverty. So what I'm hearing is, and what I've heard as a general consensus, or one of the things that I might want to propose, one of the three, that we allow urban hunting in gross management area 3.
Yes, sir. And actually, I finally got the screen to work.
Perfect.
So the map on the screen right now shows essentially available lots larger than 2 acres within city limits, excluding the historic district, schools, public rights of way, all those other exclusions that we had in there. And it also includes GMA2, essentially. So that allows more hunting opportunities where they make sense and where property owners would allow it.
And we can just take growth management area 1 out altogether. That's the downtown area.
Yes, sir.
So we remove 1. We allowed urban bow hunting in GMA 2 and 3. I think it sounds like we may have a deal from the committee. So if you don't mind, Mr. DeCane, let's hear from Councilwoman Scipio really quickly.
Just for clarity, the allowable areas are the blue areas.
Those would be areas that could be eligible for it, but you would have to obtain private property landowner permission.
What are those purple areas?
Those are the historic districts.
Okay, so they're off limits.
Yes, ma'am.
And I know the green areas are the schools.
Yes, ma'am.
So there couldn't be anything around them.
No, ma'am.
So, yeah, we could even refine that even more. Right. It's what's possible.
And it'll only be hunting by bow from raised platforms, whether that's a platform or from a deer stand only. The downward motion. So somebody standing on the ground, Mr. DeCane would not be allowed to hunt.
That is correct.
And it's 2 acres or more?
At this time.
One time it was 4 acres.
Or a combination of adjoining properties thereof.
Well, I decided my neighbor, we could stand on his porch, and between my lot and his lot, we would meet and we could just shoot to the woods across the street, but that wouldn't be what I would
Shoot
want.
down from the woods across the
Well,
street.
on his porch, it's elevated.
Okay, right, okay.
So,
I heard you. I just want to make sure we're saying the proper language. I don't want anybody would leave here morbidly afraid that people are going to be shooting arrows to their backyard. This is not the case. Councilmember Larson.
I would like to see the full range of options, which would include limitation to GM3, GM2 separately, or basically GM2 and 3 and GM3 exclusively. I would also like to look at a 3-acre limit because I'm not sure 2 acres really, deers wander from one neighborhood to the other, and somebody's going to get upset that you shot my pet deer. So I'd like to make sure we have enough massing in the property for clear claim, basically, to hunting rights of migratory animals. And so I think 3 acres begins to move us in that direction a little bit. So let's take a look. Let's take a little bit of a look at sort of what we're dealing with here and the size of the lots, as well as the location of those lots.
Mr. Larson, I'm a fan of 2 acres, but if three gets you to the table for a compromise, I think I'm willing to.
Take a look at that.
All right, let's do it.
I'd just like to see the maps. Yeah. I mean, I'm just trying to understand fully what we're dealing with here.
Councilman McIntosh.
We've got maps for 1, 2, and 3 acres here.
You have in the presentation are GMA 3 only, 1, 2, and 3 acres. The map on the screen right now is GMA 2 and 3. And I'll get those to you.
This is just information.
Just information to you.
It is.
But I'd like us to get to a point where we're ready to cut. We're measuring now. We're ready to cut maybe in March.
The other thing is that this ordinance says 500 feet from any property line or boundary of a dwelling house, a school, a church, commercial building, governmental property, and other occupied building, etc. So it might very well be, when we look at those boundaries, it's going to be very few sites that's going to be allowed. But I think we need to know that, and the public needs to know that based on this ordinance.
And that's sort of my hope for the urban core. There's not this big free fall, but those who are sort of in the county areas, or some who have large amounts of land in the urban core. But we want to keep people as safe as possible, but allow Winston-Salem should be a place where everybody can enjoy it, and hunters included, in my humble opinion.
So the licensing for hunting deer will be based on property rather than individual?
No, sir.
Okay,
you
so
get licensed through the state.
How do we determine a parcel is eligible to be hunted on? Who makes that determination?
The person who wants to hunt, just like on any other private property in the state, has to abide by those rules. So if they want to hunt on private land adjoining state lands, they still have to obtain permission from a property owner. In this case, I mean, we could go through sort of we could establish a permit process, to verify those things.
The problem I'm seeing is property boundaries change, and as this city continues to grow, that blue is going to start disappearing even more. And so we set a rule today that says you can hunt on everything on blue. And 10 years from now, you know, it's less and less possible unless, you know, we have some mechanism to say 3 acres means something. And I'm trying to understand how that is something that's enforceable or even monitored at this point.
Please do.
This is an overlay over top of Fish and Game rules and regulations, right? So if you
Correct.
want to go hunt property anywhere, you've got to go comply with and get permits to hunt on that land.
That's correct. Hunting is legal.
So we're just putting boundary limitations and saying you can only do it within this space. And if it's 3 acres, then that's 3 acres year after year after year, no matter who owns it. But you got to permit it every time you want to hunt on it, right? By the season?
Yes, sir. There's one season a year, and essentially, hunting's legal throughout the state of North Carolina.
Right.
The reason why it's not legal within city limits typically is we have an ordinance, on a weapons ordinance, that prevents discharging of weapons, et cetera. And so that's why this ordinance has to be enacted to allow hunting during the urban archery season that is established by the state. So the blue areas are just a representation, so you have an idea of roughly where they are. This is not a tool for the PD or anyone else to go out and enforce this. You know, it's incumbent upon the hunter to make sure they're in the right place at the right time. If they're not, and we get a complaint, it'll be investigated at that time. But like I said last month when we spoke to the other cities that have these programs, it's not as widely used as they ever thought it would be. They get a handful of hunters. It's just not a huge program, but it is an opportunity that could be made available to our citizens.
And if a property owner gives permission 1 year for it to be allowable and then changes their mind the next year, I mean, you're not saying forever and ever amen.
Correct.
They have the ability to change
and
their
the language in the ordinance says you have to have permission dated within 1 year of when you hunt on the property.
And if a deer is harvested, there are certain regulations that they have to go through. There's a number that has to be called. There's a permit that you have to have. I think there's 2 antlered deer and 4 other deer, so a total of 6 deer every year. So it's really regulated. So instead of us going out and policing it, the state will do it. We just allow them permission to do it inside the city regulations.
Yes, sir.
Any other further questions?
Who checks the permission slips?
The North Carolina Wildlife Resources Commission.
People do?
Right.
So it's game and wildlife and game.
Yeah, same thing with fishing.
Fine.
Just same. Yeah.
Thank you.
So nothing else needs to be crafted. We've got something we can bring back to the committee in March. Any other questions or concerns? Thank you, Mr. DeCane. Thank you to the committee. That appears to conclude our business. Now, members of the committee and Councilwoman Scipio, we typically don't allow public comment unless there is an item on the agenda that a particular resident or citizen is discussing. Today, I know that we have 2 people who have signed up to speak. What I'd like to do is, because of time, there are only 2 people who signed up to speak, so maybe we can carve out 10 minutes to hear from some of the residents who came to speak to us. Typically, in regular council meetings, we allow 3 minutes per person. Maybe if we allowed 2 minutes per person, we can get those who need to speak in. So unless there is objection, we'll allow everyone 2 minutes to speak, and we'll sort of carve out maybe 10 minutes for public comment, only considering we have 2 people signed up, but we'll allow those who may not have signed up to speak. Is there any objection? All right, so we have 2 people on the agenda signed up. One, Ms. Miranda Jones. If you'll come to the podium, if you'd give your name, address, and or supporting information for the record, please.
Miranda Jones, Southwest Ward, Winston-Salem, North Carolina. I would like for all of those who are here with me to support the Confederate statue coming down to stand up. Thank you. Councilmember Taylor and others, we are here today because we are both hopeful and mystified. We are hopeful because in the words of ancestor Reverend Dr. Martin Luther King, we've been written a check. We have been assured and reassured that the Confederate statue that sits in the heart of downtown is coming down. We were told that there have been discussions of what we like to call negotiations with racial terrorists since August of 2017. Our mayor told us that at the beginning of Black History Month that under no certain circumstances that this statue, this idol, would stay up. Yet it's still up. Yet it's still up. Tear it down. Tear it down. You might understand why it is hard for the African American community and even its white allies to believe that this abhorrent statue is still occupying space and time in our city. You might understand that this statue is still up just like other systems of oppression are still up and they must come down. You might understand that the sheer tyranny and violence of poverty and inequality remains in parts of our city that affects the most vulnerable residents. You might understand that while residents cannot get proper utilization for their taxation, their tax dollars continue to go to maintain the statue that's still up. Have you written us a check that we cannot cash? We are here. We plan to stay here. We've been called a nuisance. We've been called a public safety issue. The real public safety issue is the system of white supremacy that erected this statue. The system that invests in the west of 52 while the unsafe school buildings still stand in District 1. The system that allows ICE to racially profile and detain 9 men in the apartments off Motor Road just this week. That allocates $20 million in the new parking lots and other infrastructure projects, but includes no funding for affordable housing or public transit improvements. We, with the help of our friends and allies, have agreed to keep vigil. You say this is a public safety issue, but we have risked our very lives confronting a group who brought armed security to keep the statue still up. We brought nothing but our voices. Today we bring nothing but our voices. But we are not an echo. We are a strong vibration. We ask, can we cash the check? Get hate out of Winston-Salem. Thank you.
Thank you. Next speaker, Mr. Anthony Ndege. And while Mr. Ndege is taking the podium, I would ask that those who are here listening, that you show respect to the speaker. And if there continues to be noise while the speaker is speaking, then we'll have to rule you out of order because we want to respect everyone who's speaking. Mr. Ndege, you have the floor.
Thank you. Anthony Ndege, 1713 Chapel Street, Southeast Ward. I'm going to start out with a quote. You are Anglo-Saxons. You are armed and prepared, and you will do your duty. Go to the polls tomorrow, and if you find the Negro out voting, tell him to leave the polls. And if he refuses, kill him. Shoot him down in his tracks. We shall win tomorrow if we have to do it with guns. The quote that I'm reading is from the leader of the genocidal coup of the city of Wilmington in 1898, Alfred Moore Waddell. He's also a Confederate Army officer and co-author of the White Declaration of Independence. He was also the keynote speaker at the 1905 unveiling of the statue in question. Because of the systemic criminalization of the working class in this country in particular, but not limited to those blacker and browner areas of the nation, we've been taught to believe a skewed, often racist and punitive conception of safety that is literally rooted in the history of slave patrols. However, that definition of safety that we are taught to feel, do you feel safe walking down the streets at night? Do you feel safe in your house? That definition is a purposely very, very narrow definition and portion of what safety is. Safety is defined as the condition of being protected from harm and other non-desirable outcomes. Anywhere we go around, if you were to go anywhere door to door in most of the neighborhoods in Winston-Salem and ask, what are the top 3 things that are hurting you and your community right now? People would overwhelmingly say poverty, low wages.
Mr. Ndege, your time is up. If you can summarize, please.
Lack of access, inadequate health care, including mental health, things like that. The reason why we have low wages here in the South is because of this legacy of white supremacy and slavery that Alfred Waddell was so much of a symbol of. I was expecting to have 3 minutes, so I apologize.
Yes, sir. Well, there is no one else left to speak. We have 6 minutes left. Is there anyone else that wishes to be heard? And Mr. Ndege, I did tell you 3 minutes, and I apologize that I had to rescind that. Is there anyone else who needs to be heard? Well, Mr. Ndege, I told you 3 minutes, I gave you 2. Nobody else said you got your extra 1, so I get to keep my word today.
Winston-Salem ranks 20th in the nation for all cities for highest child poverty rates. Winston-Salem was among 3 other North Carolina cities to rank in the top 10 highest rising rates of poverty. Why? Because the cost of living is rising, but wages are not. Let's not even get to the official criteria for what the poverty line is, which is an abomination. Because of the history and legacy of slavery, and the reason why the Civil War was fought, and the very foundation of the agrarian economy that this nation was built upon, and that was the system of slavery and cheap black labor. And just because poor whites were drafted to fight does not change that fact. The Civil War was fought over the issue of ending the system of plantation slavery. Time magazine quotes, "During the Civil War, the military became the primary form of law enforcement in the South. But during Reconstruction, many local sheriffs functioned in a way analogous to the earlier slave patrols, enforcing segregation and the disenfranchisement of free slaves, to keep slaves from organizing, to reinforce the eventual sharecropping system and antiquated equipment." These are things that Alfred Waddell stood for, and this is why we should oppose the statute.
Mr. Dege, thank you for coming down to speak to the committee. Also, Ms. Jones, we appreciate your comments. To the staff who worked hard to ensure our public safety in the city, thank you for your hard work. Members of the committee, council, is there any further business that should be considered for the good of the order?
None.
Seeing nothing further, we'll consider this public safety meeting to be adjourned. Thank you.